Merci, Monsieur le Président.
Thank you, Mr. Speaker. I'd like to begin with a big thank you to my colleague from Terrebonne-Blainville, who just spoke, made a very important speech. She's worked very hard on her bill on the same subject, and I think it would be better if the member for Terrebonne-Blainville's bill had passed. That would have been so much better than this bill, S-4. And I also shared the feelings of my friend from Winnipeg North. I agreed with him. He said that everyone in the opposition here agrees with this effort. After all the other efforts that have been made, C-12 and the others, that perhaps finally the government is going to actually cooperate with the other parties. But unfortunately, that isn't what happened.
We're looking at Bill S-4, a bill that comes to us after, as you've heard from other speakers, other members, after a convoluted process, a bill that died on the order paper, a superior private member's bill that failed when the Conservatives didn't support it, in efforts to bring up to date the Personal Information Protection and Electronic Documents Act, otherwise known as PIPEDA. This is, of course, a very significant area of citizen and consumer concern. PIPEDA was passed in 2000, and a lot has changed in the world of digital information, privacy concerns, and information held by internet providers, banks, a great number of organizations for whom Canadians trust their private information online. This bill, S-4, should have been an attempt, and may in fact have been an attempt that failed, to adequately balance the privacy rights of Canadians and the important facilitation of commerce in Canada. That would certainly be the expectation. The larger context around which this bill comes to us is one where we have had some rather spectacular accidental breaches of privacy information of Canadians through their release, through various errors, human error, release of health information, release of consumer information, release of banking information because of breaches in the system. So one would have thought that, especially in this specific context in the last year, that in drafting this bill, the government would have been very cognizant of the decision of the Supreme Court of Canada of last June 2014 in the Spencer decision. That was a decision written by Mr. Justice Tom Cromwell, one of my former friends and professors from my time at Dalhousie Law School, and a brilliant legal mind, and someone who has, within the Supreme Court of Canada, written a number of really critical and important decisions. The Spencer decision is one of them. But the Supreme Court of Canada in Spencer came down very clearly on the side of privacy rights of Canadians, very clearly. Mr. Justice Tom Cromwell wrote in his decision, of course, that the Internet has exponentially, this is a quote, the Internet has exponentially increased both the quality and quantity of information that is stored about Internet users. Browsing logs, for example, are held and contain detailed information. He went on to note that a user would never really know when their information was forming some sort of pattern that resulted in review, that they don't necessarily, a user, a consumer, doesn't know when their information might be becoming accessed. But in entering into agreements with ISP providers, Supreme Court of Canada, through Mr. Justice Cromwell, noted, quote, there is a reasonable expectation of privacy in subscriber information. Now, Mr. Speaker, there's no denying that S-4 does some things that are fairly universally approved by those who are leading critics in this area. The Privacy Commissioner for the Government of Canada, of course, the Privacy Commissioner Officer of Parliament, saw a number of significant improvements. Privacy Commissioner started his review by turning his attention to the purpose of PIPEDA in the beginning, back in the year 2000, noting, quote, that the purpose is to, quote, establish in an era in which technology increasingly facilitates the circulation and exchange of information, rules to govern the collection, use, and disclosure of personal information in a manner that recognizes the right of privacy of individuals with respect to their personal information and the need of organizations to collect, use, or disclose personal information for purposes that a reasonable person would consider appropriate in the circumstances. Now, fortunately, given the fast-changing world of digital communication, internet, and the clouds and all the various ways in which we now see information stored online, fortunately, Parliament saw fit in the year 2000 to include a 5-year mandatory review of PIPEDA so that we could keep up with the ways in which technology moves so rapidly. So, generally speaking, some of what is being done here is met with universal support. The risk-based approach that allows organizations to assess each incident on a case-to-case basis was supported by the Privacy Commissioner, at least. The Commissioner has an opportunity, the Privacy Commissioner has an opportunity to enter into compliance agreements, but while the Privacy Commissioner found this acceptable, numerous other commentators did not feel it went far enough and did not actually protect privacy information adequately. So the things that met universal approval, if I can list them briefly, Mr. Speaker, improvements in S-4 include the additional qualification and clarification of what's meant by the standard of consent, the extension of a deadline to take cases to the federal court, and, of course, the additional powers, the expansion of powers to the Privacy Commissioner to publicly disclose information related to findings. These were things that the Privacy Commissioner liked. Leading critics, and my friend from Terrebonne-Blainville has already pointed to one of the leading critics in this area, Professor Michael Geist, as well as to the advisors and a very exceptional group of lawyers who now work a lot on information and privacy law at the Public Interest Advocacy Center, where in the 1980s I was also Associate General Counsel, although in those days, you can believe me, we didn't have open files on internet data and privacy because we were mostly dealing with trying to advocate in areas of technology that now seem so outdated. But in any case, the Public Interest Advocacy Center has stayed on top of the technology. So we have, from the Canadian Bar Association, Public Interest Advocacy Center, Professor Michael Geist, and of course, members of opposition parties, we had a rich group of substantive and helpful amendments which would have led to universal support for this bill at this moment. And unfortunately, those amendments were all rejected. I want to just look at 3 aspects here in the time I have left this afternoon, Mr. Speaker. Compliance agreements, the expansion of voluntary disclosure, and lastly, transparency reporting. Now, on compliance agreements, there's a source of concern that the way in which they're drafted in S-4 would have been acceptable had they been strengthened and had penalties or an order-making power available to the Privacy Commissioner, but they have none of those things. The Canadian Bar Association brief made this point about it, that our principal concern is that while entering into such an agreement with the Privacy Commissioner stays any court enforcement by the Commissioner, it does not have any effect on any affected individual's right to go to court against the organization for the same matter under investigation. This omission means that there is a much lower incentive for organizations to enter into such agreements. Also, it is not consistent with the regime in other similar schemes. Now, despite recommendations to improve this, no improvements were made. Secondly, Mr. Speaker, the expansion of voluntary disclosure. This is probably, for me, the most significant failure of S-4 and quite inexplicable in that it runs directly counter to the Spencer decision I referenced earlier. This needed to be, to have much more rigor to ensure that we didn't have warrantless access. This is the key issue here. We must have come down, S-4 should have come down harder for privacy rights. And lastly, Mr. Speaker, in transparency reporting, there should have been reforms to require organizations to publicly report on the number of disclosures they make without knowledge or consent and without a judicial warrant. This information should have been disclosed on a regular basis for transparency, and organizations should have been required to notify affected individuals within a reasonable time of any accidental disclosure. With that, Mr. Speaker, I regretfully conclude that S-4 does not meet the standards that this Parliament should expect of an update to PIPEDA. Thank you.